पॉलिसी बाजार पर 1 करोड़ रुपए का टर्म लाइफ इंश्योरेंस केवल 450 रुपए महीने से शुरू। Wow.
The government has got a huge shot in arm with this majority judgment as far as the demonetization is concerned. But let's try and understand this. The Supreme Court is only looking into the process, whether the process was constitutionally legal, whether all the the laws and the various subsections and as mandated by the RBI Act, all those were followed. So the Supreme Court has kept its view on that, and it has upheld that this was a legal process. The questions on Article or Section 26(2) of the RBI Act, where RBI should have initiated the process, did the centre initiate the process, was proper time given as far as the entire consultation process is concerned. The court said that 6 months there was consultations going on between the government of India and the RBI. They were kept secret so that this process or the decision does not leak. Apart from that, whether the government could have legally demonetized the entire series of the note and the time given to the people to exchange their note, the 52-day window, all that has been upheld by the Supreme Court with a majority verdict. There has been a dissenting verdict as well, quite strong, words being used, unlawful. The RBI did not, in fact, apply its mind independently. All those has been said by Justice Nagaratna. But the fact is that today, at least legally, this law, this entire process, the executive process of the government of India has been upheld by the Supreme Court. Questions on objectives, whether those objectives have been met, whether there has been any shift of the goalpost from the government when it talks about why was the demonetization policy brought in and whether it has achieved all those objectives, those still remain. Those questions are open for debate as far as the political parties are concerned. But as Priyanshi was pointing out, the opposition that is exactly what the opposition is looking at. Mr. P. Chidambaram, in fact, tweeting and in his tweets, he has said that the dissenting judgment will rank among the famous dissents recorded in the history of the Honorable Supreme Court. The fact is, ladies and gentlemen, that the opposition at least trying to, in a way, hold on to that one dissenting judge, while the government will, of course, come across and talk about the majority view and, of course, the decision as far as the Supreme Court is concerned. He also said it is necessary to point out that the majority has not upheld the wisdom of the decision, nor has the majority concluded that the stated objectives were achieved. In fact, the majority has steered clear of the question whether the objectives were achieved at all. Mr. Chidambaram, remember, is one of the lawyers as far as this petition is concerned. And this is what, Priyanshi, the legal question on the process could have been answered. They curtains on that. But the fact is that the politics around the demonetization policy will continue, and the government will get a lot of ammunition, in fact, to hit back at the opposition with these, with this majority verdict.
The fourth one is whether there was proper relation between the importance of the purpose to be achieved and the limitations on the constitutional rights, and applying all these four tests. We have held that the action cannot be hit by the doctrine of proportionality. Then issue number 5, with regard to reasonableness of period is concerned, we have considered that in the 1978 Act, the period provided was only 3 days, and which was extendable by a further period of 5 days. And this has been found to be a reasonable period in the case of Jayantilal Shah by the Constitution Bench. In the present case, the period provided is 52 days, and therefore, applying the principles laid therein, it cannot be said to be an unreasonable period.
In my considered view, the action of demonetization initiated by the central government by issuance of the issued notification dated 8 November 2016 was an exercise of power contrary to law and therefore unlawful. Consequently, the 2016 Ordinance and 2017 Act are also unlawful.